Mohammed Abdul Karim, and Standard Alliance Insurance PLC. My Lord, the party down.
Appearance.
If it pleases my noble Lord, my name is Remigius Ani. My Lord, I most humbly announce appearance for the claimant. We sincerely apologize for the absence of the claimant, even though I know the claimant has this link. Maybe he's watching from somewhere, my Lord.
It's all right.
Ask God, please.
No appearance for the defendant. I'm the defendant himself.
This one has been.
Where is the evidence of service? Huh?
Please, is your laptop connected? Is it connected?
My Lord, the defendant was in court as at the last adjournment.
Yes, I know.
Presented, my Lord.
Yes. I said connect this light.
It's connected.
It's not connected. It's connected. Yes, this matter is for judgment.
Ask God, please.
The judgment will be read virtually.
Ask God, please.
By the exhibit CW1B1 to 3, letter dated 2nd day of November 2010, the claimant in this suit was offered employment by the defendant to the position of business manager, Kano office. The employment of the claimant took effect from 8th of November 2010. The claimant dutifully served the defendant, and in appreciation of his service to the defendant, his employment was confirmed by the exhibit CW1C, letter dated 30th day of November 2011. The confirmation took effect from 1st of January 2012. The confirmation of claimants came with upward review of his salaries, of his basic salary, from the sum of 550,000 naira per annum to 605,000, effective 1st day of January 2012. Due to the claimant's exceptional commitment to hard work, selfless sacrifice, and dedication to service, he was commended severally by the defendant, and his salary was reviewed. See exhibit CW1D and CW1E. As a result of the commendation, the claimant's basic salary was raised from 605,000 naira to 635,250 naira, with effect from 1st of March 2013. The claimant stated that from October 2013 to February 2017, his monthly salary after deduction stood at the sum of 313,651 naira 19 kobo, while leave and medical allowances were each being paid in a single payment once in a year. The sum of 473,000 naira was the last payment made to the claimant for his medical allowance, while the last annual leave allowance paid to the claimant for the year 2016 was the sum of 65,000 naira. According to the claimant, apart from letter of employment exhibit CW1B, no staff handbook was issued to him by the defendant. For the 7 years the claimant served the defendant, no staff handbook was issued to him. On the 15th, however, on the 15th day of March 2017, the defendant served the claimant with exhibit CW1I1 to 2, titled Commencement of Pay for Performance Policy, a reference to alleged staff handbook, which the defendant never issued to the claimant, and mandated the claimant to accept the terms of the letter stipulating the new way in which the claimant's financial compensation will be structured in the company, and by necessary implication, amend the terms of the claimant's contract of employment. The claimant refused to accept and owe consent to the terms as contained in exhibit CW1I1 to 2, due to the defendant's unilateral and retrospective slashing of the claimant's salary down to 30%. From the month of March 2017, the defendant decided to be paying the claimant 94,000 naira, contrary to the existing monthly payment, despite the fact that claimant never assented to or consented to the purported pay for performance. To the greatest surprise of the claimant, the defendant on the 1st of November 2017 served the claimant with exhibit CW1H, a letter dated 31st day of October 2017, terminating claimant's employment without any notice or state reasons whatsoever for terminating claimant's employment. As at the time of termination of the claimant's employment, the claimant had worked for a complete 10 months in the year 2017, and the claimant is due for payment, and the claimant has not gone on his annual leave. Therefore, he is entitled to his annual leave allowance as well as his medical allowance for the year 2017. Due to lack of any indication of the dependent paying claimant's entitlement, the claimant decided to return the official Rio saloon car allocated to him for his official duty as a lien for outstanding arrears of salary, allowances, and entitlement which the defendant had not paid or expressed intention of paying. The claimant instituted this action to challenge the action of the dependent in terminating his appointment and refusal to pay his entitlement. The claimant commenced this action on the 16th day of November 2017 by way of complaint and statement of facts establishing the course of action, claiming against the defendant as follows: a declaration that the defendant's abrupt termination of claimant's employment was wrongful and in breach of the contract of employment duly signed by both parties on November 2nd, 2010. 2, a declaration that the claimant is entitled to all outstanding arrears of payment, salaries, allowances, and all the entitlements due from the defendant to the claimant under the said contract of employment duly signed by both parties on the 2nd of November 2010. He is also claiming the sum of 1,526,358 naira 33 kobo, being the aggregate arrears of deductions of the claimant's monthly salary payment by the defendant at the rate of 218,051 naira 19 kobo, from the month of March 2017 to September 2017. He is also claiming in relief for the sum of 219,101 naira 19 kobo being arrears of deductions of claimant's monthly salary by the dependent for the month of October 2017. Then he is claiming the sum of 312,651 naira 19 kobo being salary in lieu of 1 month's notice of intention to determine the employment of the agreement. Is for the sum of 470 pounds of the claimant, for their 27,000 naira is for payment of leave allowance of 500,000 naira, cost of filing and prosecution of this case. The claimant is also claiming 20 million naira as general damages for hardship, inconvenience, pain, and suffering. He is also claiming for interest and such other orders. Upon being served with the originating process, commencing this suit, the dependent filed statement of defense on the 9th day of July 2018, wherein the dependent incorporated a counterclaim praying for, 1, a declaration that the claimants continued holding over a refusal to return, deliver to the claimant, counter-claimant's vehicle, Kia Saloon car, with registration number KSF 469DN in compliance with the claimant's contractual obligation is wrongful and has occasioned damage and or injury to the claimant, to the counter-claimant. 2, an order directing the claimant to return and or deliver all company properties to the counter-claimant, inclusive of Kia Saloon car with registration number KSF 469DN previously given to the claimant as official vehicle. 3, an order directing the claimant to pay the counter-claimant the sum of 5 million naira being damages caused by the claimant for depreciation of the use and enjoyment of counter-claimant's property, and for cost against the claimant for this counter-claim. In the defense to the claimant's claim, the dependent maintained that the claimant's employment was properly and effectively terminated in accordance with the contractual obligation contained in the claimant's employment, Exhibit CW1B, and there was no outstanding payment to be made to the claimant. It is the case of the claimant that copies of the dependent's handbook was at all material time available to every member of staff of the dependent, and the claimant ought to have knowledge or ought to have had knowledge of the dependent's handbook and the terms and conditions of his employment. I will keep reading the submissions of counsel on the case, but I have reproduced the submissions in the body of the judgment. I will go straight to the decision of the court.
Let's go, please.
I have carefully considered the processes filed, the evidence laid, and submissions of the parties. The claim of the claimant is a mixture of declarations and monetary claims. For the claimant to succeed on the declarations, he must rely on his own case and not on the weakness of the defendant. See the case of Idu and host of other cases cited therein. For the monetary claim on salary deductions or balance of salary, medical and leave allowances, being monetary claims are in the nature of a claim for special damages. So for the claimant to succeed in his claims, he must prove the twin issues of his entitlement to the claims and how he came about the sums he's claiming from the court. And he must do this with concrete, cogent evidence. This court has said time without numbers that in labor relations, the burden is on the claimant who claims monetary sums to prove not only entitlement to the sums, but how he she came about the quantum of the sum. And proof of entitlement is obtained by reference to the instrument or document that grant it. In the case of Mohammed Dungus and others versus ENL Consortium Limited 2015, 60 NNLR, part 208, page 16, page 39. It is not only oral testimony of the claimant. No, not only the oral testimony of the claimant that can establish his claim. That oral testimony of the claimant must be corroborated for it to establish special claim for special damages. In law, the onus of proving claim of special damage pretty onerous. See the case of 7-Up Company PLC versus Augustus. For instance, it held that a claim for gratuity, pension, housing, fund, salary is a claim for special damages, which must be particularized and strictly proved. And by the case of NNPC, Kilipo Nigeria Limited, the claim for special damages cannot succeed because it is admitted. Claims for special damages are never inferred from the nature of the act complained of. They do not follow in the ordinary course as in the case with general damages. They are exceptional and so must be claimed specifically and proved strictly. The fact that it appears to be admitted does not relieve the party claiming of it of requirement of proof with compelling evidence. From this case law, the case law authorities, even if the defendant had admitted claim of the claimant, it is not sufficient to be proof of the claims for special damages. The claimant will still have to convince the court that he is entitled to the claim. The Supreme Court in the case of Gabriel Atibi versus Cable Metal Nigeria Limited has this to say: a claim is circumscribed by a relief claim. The duty of plaintiff, therefore, is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove them. He may, at the end of the day, obtain all the reliefs claim or less. He never get more, nor does he obtain reliefs not claimed. A court is therefore bound to grant only reliefs claim. It cannot grant reliefs not claimed. Looking at the claimant's claim, reliefs 1 and 2 are for declaration to the effect that the defendant abroad termination of claimant's employment was wrongful and in breach of the contract of employment duly signed by the parties on the 2nd day of November 2010, and that the claimant is entitled to all outstanding arrears of payments, salaries, allowances, and all the entitlements due from the defendant to the claimant under the said contract of employment duly signed by both parties on 2nd day of November 2010. The evidence adduced by the claimant in proof of this case is as contained in his witness statement on oath adopted before the court in the course of giving evidence in chief and the exhibit tendered. The claimant was by the exhibit CW1B3 employed by the defendant to the position of business manager. The claimant accepted the offer and resumed duty on the 8th of November 2011, see exhibit CW1-3. After satisfactory performance of appointment, the appointment of the claimant was confirmed by the exhibit CW1C, and his salary was reviewed. And due to his hard work and commitment to duty, the defendant commended the claimant and also further reviewed his salaries to 635,000 naira, 250 naira per annum. See Exhibit C, CW1D, CWE, and CW1F. Despite the commendation received by the claimant from the defendant, the claimant's employment with the defendant was terminated by the Exhibit CW1H. However, prior to the termination of the claimant's employment, the defendant issued letter dated 15th day of March 2017 to the claimant with the title Commencement of Faithful Performance. The said letter was tendered and admitted in evidence as CW1 I-1-2. The claimant is contesting the validity of termination of his employment by the defendant without notice, reason for termination or payment of 1 month's salary in lieu of notice. He is also asserting that he is entitled to payment of his full salary from March 2017 to first day of November 2017, when he was served with Exhibit CW1H terminating his employment. The defendant has strenuously argued that the claimant is not entitled to relief being sought before the court. It is a position of the defendant that it had not breached terms and conditions of service governing the employment of the claimant, as the claimant's condition of service include Exhibit DWA staff handbook by way of incorporation, and the issuance of Exhibit CW1 I-1-2 is in furtherance of Clause 13A of Exhibit DWA, which allows the defendant to modify or come up with new policies on salary of its employee. However, the claimants insisted that Exhibit DWA is not binding on him, as the defendant has never made it available to him. According to the claimant, Exhibit DWA is a document that has no evidential value as it was not signed. The claimant has also stated that the defendant cannot unilaterally reduce his salary without his consent. The defendant, on the other hand, has argued that the claimant, having received payment based on new policy from March 2017 to October 2017, has consented and cannot be heard to be complained. In labor jurisprudence, where the termination of employment without statutory labor is in focus, the terms and conditions of service are the bedrock based on which the determination of the issue of wrongfulness of employment must be based. See the case of Amodu versus Amode. See also the case of Tato versus CBN. See also the case of Okomo Oil Farm and Isere. That's why the court is not entitled to look outside the contract of service at the terms and conditions for the terms and conditions of service. The terms and conditions of must be gathered. Therefore, from other sources which can be incorporated, by reference to the contract, as the case may be. It is the best way of deciding the right of parties under the contract. The Idigbe versus College of Medicine, University of Lagos, the International Drilling Company Limited versus Ajijala, the Idigbe Obo versus NNPC. In view of the stance taken by the parties on the actual terms and conditions of service governing employment of the claimant and the defendant, it is pertinent to state here that the terms and conditions of service are most often not signed or even dated. Employees are also not required to sign conditions of service. In other words, the applicability of terms and conditions of service or staff handbook is not dependent on their being signed, dated, or signed by either of the employer or employee. See the case of Mrs. Rosalind Eken versus National Energy Insurance. In the case at hand, the CWB 1 to 3, the letter of claimant's employment dated 2nd day of November 2010 clearly has incorporated the provisions of staff handbook as part and parcel of the terms of and conditions of service governing the employment of the claimant. Therefore, in any dispute arising out of the claimant's employment, Exhibit DWA must be part and parcel of the document to be considered by the court in order to resolve whatever dispute that may arise or require a resolution. For this court to determine whether the termination of claimant's employment as evidenced in Exhibit CWMH is proper or wrongful, or whether the dependent carried out termination of claimant's employment following due process, the court is bound to examine Exhibit CW1B1 to 3 and Exhibit DWA as the document governing the employment of the claimant with the dependent. In Exhibit CW1B1 to 3, on termination, it was stated that, I quote, on confirmation of appointment, however, either party may determine the employment by giving 1 month's notice intention of to do so, or by payment of 1 month's salary in lieu of notice. Please, we need silence. Hello, administrator, mute all the participants, please. In Exhibit DWA, clause 5E dealing with termination of employment, stroke resignation of appointment, it provides, I quote, termination, resignation of appointment shall be subject to 1 month's notice or payment in lieu, except in case of summary dismissal. This will be in accordance with the employee's contract of employment. Accrued leave in respect of completed calendar month service may be incorporated into the notice, unquote. It is apt at this juncture to reproduce the content of Exhibit CW1H, the letter of termination of claimant's employment. I read, it provides as follows. Date October 31st, 2017, addressed to Mr. Baba Abdul Karim Mohammed, CEO Standard Alliance Insurance PLC Abuja FCT. Dear Mr. Mohammed, management wishes to inform you that your services are no longer required by the company effective 31st day of October 2017. You are therefore directed to hand over all company properties in your possession, including your identity card, to the regional head office, Abuja. You will be advised of any outstanding payment due to you from the company management Management wishes you all the best of luck in your future endeavors. Yours faithfully for Standard Alliance Insurance, signed in Kiruka Uzoichi, Divisional Head, Human Capital Management Legal. The above quoted content of Exhibit CW1S speaks for itself. According to the letter, the claimant's termination takes effect from 31st day of October 2017. The date the letter of termination was prepared or issued by or written and issued to the claimant. This means that the claimant's disengagement was with immediate effect. This court has consistently held that termination or dismissal made to take effect on the date of the letter of termination or dismissal is one without notice and with immediate effect. In the recent case of Yunus Adewale versus Adepoe versus MTN Communications, a reported suit NICM judgment delivered 15th May 2019. This is what the court said in paragraph 31. In terminating the claimant's appointment with effect from 16th June 2016, Exhibit 2016 of the same date terminated the claimant's appointment with immediate effect. This means that the termination was without notice. Exhibit CW1H clearly shows that the defendant did not give any notice to the claimant in terminating his appointment. This has also goes to debunk the waft argument canvassed by the defendant on the claimant's continue to work till November 2017, which according to him metamorphosed into notice of termination. For any notice of termination to be valid, it has to be given in line with the terms and conditions of service, Exhibit CW1B123 and DWA, which are clear and unambiguous, and demanded that 1 month's notice shall be given for termination of employment or payment of 1 salary for payment of 1 month's salary in lieu of termination. In the case at hand, Exhibit CW1 stated you will be advised of any outstanding payment due to you from companies. This means nothing is said about payment of salary in lieu of notice. This means claimant has not been paid his salary. Has not been paid 1 month salary in lieu of notice. This means that the termination has contravened the clear and unambiguous provisions of The terms and conditions of service are shown in Exhibit CW1B3 and DWA. From the point, there is no doubt that the termination of claimant's employment by Exhibit CW1HA was wrongful for two reasons. It was without notice. First, it was without notice, and second, there was no payment of one salary in lieu of notice. Accordingly, the argument of the defendant that the defendant has not proved relief 1 and 4 must be rejected. The claimant has proved entitlement to relief 1 and 4, and same succeed and are hereby granted. This is because where the court makes a finding of wrongful dismissal termination, a payment in lieu of notice will apply. See the case of Western Nigerian Development Corporation versus Abimbola. See also Nigerian Produce Marketing Board versus Adewumi. See also the case of Interdrilling versus Ajijala. See Olatum Bosun versus Nisa. See also Ipeta versus Shell. See Gedem versus Nefa. See Nwabua. See Van versus Golden Guinea Breweries. See also Chukuma versus Shell Petroleum. See Iduefeko versus Pfizer. I now turn to the remaining reliefs being sought by the claimant. By the decision in the case of Udwa versus FCDA, reported in 2003, 10 Nigerian Criminal Report, Part 829, page 487, the Supreme Court has made it clear that in a claim for wrongful termination of appointment, an employee can also claim for salaries, leave allowances, etc. earned by the employee, but not paid by the employer at the time of termination. So the new dispensation is that whether termination or dismissal is wrongful or not, all earnings of an employee prior to the termination or dismissal must be paid by the employer to such an employee. See the case of Odua Gans Sufra. See also the case of Underwater Engineering Company Limited versus Bubipom. See also Adebayo versus Adebayo Boye versus FBN Mortgage Limited. Relief 3 is for the sum of 1,526,358 naira 33 kobo, being aggregate arrears of deductions of claimants' monthly salary payment by the dependent at the rate of 218,051 naira 19 kobo from March 2017 to September. And the relief 4 is for the payment of 219,101 naira 19 kobo, being the claimant's monthly salary, deduction of monthly salary for the month of October 2017. The facts pleaded and evidence adduced in proof of these reliefs can be found in paragraphs 10, 13, 14, 15, 19, 20, 21, 22, 23, 26, 28, 32, and 33 of the statement of facts. They are also found, they can also be found in paragraphs 12, 15, 16, 17, 20, 21, 22, 23, 24, 25, 28, 30, 31, and 32 of the witness statement on oath. The claimant grounds against the dependent regarding these reliefs is that the dependent cannot decide unilaterally without the consent of the claimant to reduce his salary or guarantee only payment of 30% of the claimant's salary. According to the claimant, Exhibit CW1 I1 to 2, with title commencement of pay for performance policy, goes contrary to his contract of service with the dependent as depicted in Exhibit CW13, more so that he has not even consented to it. The claimant tendered Exhibit The claimant tendered Exhibit DW1E, a letter dated 19th of February 2013, reviewing his salary. He also tendered Exhibit CW1G, pay slip for October 2013, to show his salary after the review. which was the salary he had been collecting from the dependent up to February 2017. And following issuance of Exhibit CW11 to 2, the claimant's salary was slashed, and the dependent, with effect from March 2017, was paying the claimant the sum of 94,000 naira instead of 312,000 till September 2017. And on the 7th day of November 2017, the claimant was paid the sum of 93,600 for the month of October. The claims of the claimant as per reliefs 2, 3, and 4 is for unpaid balance of his salary from March 2017 to October 2017. The dependent in justifying the action taken by issuance of Exhibit CW11 to 2 refers to the provisions of Exhibit CW1B1 to 3, where the staff handbook was incorporated as part of the terms and conditions of service governing the employment of the claimant. The provisions of Clause 13 of the staff handbook Exhibit DWA was referred to as the authority for issuance of Exhibit CW11 to 2. It was also argued that the claimant has consented and acquiesced since he did not complain or protest his employment was terminated by the defendant. The defendant insisted that the claimant is not entitled to the balance of his unpaid salary due to the change of policy on salary. The right to receive salary or wages is determined by letter of appointment. See the case of Jeremiah versus Idigbe and another 1996 7 Nigeria Ukulolo report. See also Chemical and Non-Metallic Products Staff Association versus Benue Cement Company PLC, reported in 2006 5 NLR part 14 page 1. This court had stated that, as stated, time was outnumbered, that the law regards issue of salary as sacred. It is sacrosanct. It cannot be tempered. It cannot be tempered anyhow by the defendant without the consent of the claimant. The interest in employment for most workers is wages to earn a living. The employee contracts to extend his services for the remuneration he will be receiving from the employer. The employee's remuneration or wages is determined by the letter of employment or collective agreement. The employer's duty to pay agreed wages does not permit unilateral reduction in the wages. Howsoever, this position is in accord with good and international best practices in labor. The dependent has argued that I'm having problem with this. Maybe I will have to change. Use another device. Yes, Council, are you hearing me? Okay. Yes, I continue from where I stopped.
As call pleases.
The defendant has argued that Exhibit CW1 to 2 is not in any way for slashing claimant's salary. However, a careful perusal of Exhibit CW1I1 to 2 clearly reveal that for the said policy to take effect or become operational, the employee, that is the claimant in this suit, must consent by appending his signature, signifying his concordance with the policy. Since Exhibit CW11 to 2 required being signed by the claimant, the absence of the claimant's signature on the exhibit has rendered it impotent and ineffective, and the defendant has no right, in the absence of the claimant's agreeing to the change of policy, to start deducting claimant's salary based on the policy that is yet to take effect. The defendant has unconvincingly argued that the claimant has consented or acquiesced to the policy by not complaining. This position was clearly based on great misconception. The only way consent can be established is by appending signature. The claimant refused to append his signature on the document. This means that he disapproved of the policy. The defendant has also argued that the policy is not meant to reduce or slash claimant's salary, but meant for payment to be based on performance from March 2017 to October 2017. The defendant has not adduced any evidence before the court to show that it complied with the terms of Exhibit CW11 to 2. There is nothing before the court to show that claimant has not performed. There is also no evidence of the purported month's budget for the claimant which he failed to achieve. In view of the foregoing, I have no choice than to declare that the claimant is entitled to all his outstanding arrears of payment of balance of his salaries from March 2017 to October 2017. Reliefs 4 and 3 are for payment of medical and leave allowances. The claimant has averred that these allowances are paid once in a year. He also tendered Exhibit CW1K2 to CW1 showing payment of which he claimed are for the 2 allowances. The defendant is of the view that the defendant is not entitled to these reliefs because there is no narration stating that the payment are for medical and leave allowances. And he failed, and the defendant failed to state what he has paid to the claimant as his leave allowance and medical allowances for the said period for which the claimant alleged he was paid. As pointed out earlier in the claim for allowances such as medical and leave allowances, the claimant is required to establish what makes him to be entitled to his claim and prove the actual amount which he is entitled to. In Exhibit CW1B1 to 3 has made provision for payment of medical allowance in the sum of 200,000 naira. There is also provision for payment of 15% of basic salary as leave allowance. In clause 17 of Exhibit DWA Staff Handbook, provision for payment has been made for payment of leave allowances. However, the column for the percentage to be paid was not legible in the circumstances in view of the fact that the defendant who relied on Exhibit DWA has not tendered legible copy of the said exhibit. I have no choice than to fall back to Exhibit CW1B3, that is the letter of employment of the claimant, which has made provision for payment of leave allowances. And in that document, 15% of the basic salary is the amount to be paid as leave allowances to the claimant. In clause 25, provision has also been made for medical scheme HMO medical allowances, but the content of the clause is not legible. Since it cannot be read, resort will have to be made to Exhibit CW 1 to 3, which provide for payment of the sum of 230,000 naira as medical allowance. Relief 8 is not. This means that the claimant has proved that he is entitled to his medical allowances and leave allowances as provided for in Exhibit CWB 1 to 3. However, reliefs 8 and 9 and 10 have not been proved. Therefore, they are not grantable. They are claims for damages which have not been proved by the claimant. While relief 10, which is for remittance of pension, has been overtaken by event with the admission of the claimants under cross-examination that the claimant has, after the institution of this case, remitted certain amount into has remitted the balance which is claiming. Relief 10 is for interest which is at the discretion of the court. I now go to the decision on counterclaim. I have in the early part of this judgment reproduced the reliefs being sought by the defendant claimant to counterclaim. In the circumstances, there is no need to reproduce it again. The law is right that a counterclaim is a cross action with separate pleadings, judgment, and cost, and not merely a defense to the claim before the court. It is an independent action that is not part of the original action, although for convenience they are being tried together. In such trials, parties in the original action swap places. The defendant assumes the position of the claimant and the claimant assumes the position of the defendant. Thus, a counterclaim is a weapon of defense that allows the defendant to enforce his claim against the claimant as effectually as an independent action. See Okoronko versus CCB, see also Umar versus Gedam. A counterclaim being a separate and independent action is triable with the main action for the sake of convenience. It must be proved it must be proved by the counterclaimant in order for him to earn the favor of the court. The defendant can display and append its counterclaim to the main claim like the main claim. However, it must be proved by the counterclaimant in order to be entitled to it. This is because the onus of proof remains with he who assert or person who claim a relief must prove it by cogent credible evidence. The burden is on the counterclaimant to prove his counterclaim. See Sufcom versus Pet Services Limited. See Adan. In the counterclaim under consideration, the reliefs being sought consists of declaration and monetary claim, which in law amount to claim for special damages. The first and second reliefs goes together, as the grant of first reliefs, which is for declaration, will result in grant of the second relief. The second relief is an ancillary relief dependent on the grant of the first relief. The first relief being for declaration must succeed on the strength of the counterclaimant case and not on weakness or admission of the claimant dependent to counterclaimant. The claim in the counterclaim are with respect to Kia Saloon Car registration number KSF 469DN allocated to the claimant dependent to counterclaim in carrying out his official duties while in the services of the dependent claimant to counterclaim. The Kia car was allocated to the claimant dependent to counterclaim on 21st day of July 2015 by the Exhibit CW1K. The dependent has tendered Exhibit DWB 1 to 3 in proof of ownership of the car. The claimant dependent to counterclaim has admitted withholding the Kia car as a lien due to non-payment of his entitlement following termination of his appointment by the dependent. There is no disputing the fact that the claimant dependent to counter-claimant is in possession of the car belonging to the dependent. With the termination of the claimant's employment, the car belonging to the dependent, which was allocated to claimant to counter-claimant by virtue of his position by the XBCW, ought to have been returned to the dependent claimant to counter-claim. The claimant insisted that he withheld the dependent's car due to non-payment of his entitlement and lack of indication to settle the claimant defendant counter-claimant entitlement. The dependent claimant to counter-claim is entitled to his car, while the claimant defendant to counter-claim is equally entitled to have his entitlement paid to him contemporaneously with the decision to terminate his services, though that has not happened in this case. On the relief seeking for payment of 5 million naira, the Ipse Dixit of DW1, the witness of the defendant to counter-claimant, is not enough to establish the payment of the claim of 5 million, as the said claim is a claim for special damages, which has to be proved strictly by the defendant. There was no evidence adduced by the claimant to show how the loss was incurred and what is the actual amount what is the actual amount incurred. The failure of the claimant to establish the special claim strictly has entitled him to this relief. It should be remembered that multiple claim of this nature is a claim for special damages, which the law requires the claimant to specially particularize and prove same. The dependent claimant to counter-claim did not particularize the claim. A lump sum is claiming for a lump sum. This fell short of the requirements of the law regarding pleading concerning special damages. See the case of Ogbonna versus Attorney General Imo State. See also Impact Solution Limited versus International Breweries. See also Olubodan versus Lawal. See also Africa Songs Limited versus Adega. The dependent claimant to counter-claim has not discharged the onus of proof reposed on him by law, because the dependent counter-claimant is subject to the same rule regarding proof. In the case at hand, there is no satisfactory proof of entitlement to the counter-claim to the payment of 5 million as special damages. The evidence laid did not satisfactorily convince the court that the claimant is entitled to 5 million naira damages or special damages for the use or depreciation of the car. In the circumstances, the defendant claimant to counter-claim has willfully failed to prove entitlement to the sum of 5 million naira as being claimed. From all I have been saying above, both the claimant dependent to counter-claim and the defendant claimant to counter-claim have to some extent proved facts of their respective reliefs. For avoidance of doubt, the orders of the court are as follows. The abrupt termination of the employment of the claimant by the dependent by the XBCW1H was wrongful and in breach of the clear provisions of XBCW1B and XBDWA respectively. The claimant is entitled to payment of 1 month's salary in lieu of notice of termination. The dependent is hereby ordered to pay the claimant the sum of 312,000 naira, being payment of 1 month's salary in lieu of notice of termination. And the claimant is also entitled to balance of his unpaid salaries from March 2017 to September 2017. The claimant is entitled to payment of the sum of 1,500,000 for the balance of his unpaid salary. He is also entitled to payment of 219,000 as balance of his salary for the month of October. The claimant is entitled also to payment of 230,000 as medical allowances as provided in Exhibit CW1A, CW1B1 to 3. The defendant is hereby ordered to pay the claimant the sum of 230,000 as his medical allowances and not 477 as claimed by the claimant. The claimant is also entitled to payment of his leave allowances, 15% of his annual basic salary by the Exhibit CW1E. The annual basic salary of the claimant as at the time of termination of his employment is 635,250,000. 15% of this amount will amount to 95,289 naira 50 kobo. However, the claimants claim 65,000 naira. In view of the claim being lesser than the amount which should have been entitled, I award the lesser claim, as the court cannot award more than what is claimed before it. Therefore, the defendant is hereby ordered to pay the claimant 65,000 naira as his leave allowance. The leave allowance and the medical allowances are to be paid for the complete year because of the doctrine of arithmetical approximation. The claimant has served the defendant for more than half of the year. Therefore, he is entitled to payment for the whole year. The claimant is hereby ordered to return the defendant claimant to counterclaim Hakiario Salunka with registration number KSF 469DN in good working conditions. Parties are to bear their respective costs. All monetary awards as per this judgment must be settled within 30 days, failing which interest of 10% shall apply. Judgment is entered accordingly. Call the next.
Morning, my lord.
Yes.
My apologies for joining proceedings late. I have a matter at the Supreme Court. I have to step out to join the proceedings. My apologies for joining the proceedings late. I have a matter at the Supreme Court. I have to step out at the foyer to join these proceedings. My name is Babatunde Ige, counsel for the defendant counterclaimant.
You have to make yourself visible. You have to put on your video for me to record you. If I can't see your face, I can't record you.
My lord, my video is on now, sir.
Yes. Babatunde
Ige.
Was the defendant?
Yes, my lord.
Yes, judgment has been read.
Yeah, we're grateful for your lordship's judgment.
You are welcome. Yes, registrar, call the next case.
Suit number NICN CA 2021 between the Master of Farm Market Traders Welfare Association to Mr. Macaulay of Farm and 1 National Union of Shops and Distributive Employees to Mr. Asupo Eke. 3 Mrs. Grace Robert for Calabar Municipal Council. My lord, the second claimant on record is present.
This one is for Pisca.
Yes, my lord.
Okay. Administrator, you can end the sitting.